Dr. Ashfaque, a doctor from Dhaka Medical College, University of Dhaka, has worked in various countries before coming to the UK in 2018. He has held positions at several NHS trusts, including the University Hospitals of Morecambe Bay NHS Foundation Trust, the Isle of Wight NHS Trust, and the East Lancashire Hospitals NHS Trust. Currently, he is employed as a junior clinical fellow in the care of the elderly at the Barking, Havering, and Redbridge University Hospitals NHS Trust. The allegation against Dr. Ashfaque involves providing false information and documents during his UK visa applications between August 2017 and October 2021. Specifically, he allegedly provided untrue information about the dates of birth of his two youngest sons, Mr. A and Mr. B. It is claimed that he knowingly provided false information and made false declarations in support of his visa applications. The allegation also included dishonesty on Dr. Ashfaque's part. During this period, Dr. Ashfaque made several visa applications for himself, primarily to sit medical exams and register with the General Medical Council. He initially obtained a Tier 2 General Work Visa in November 2017, which was subsequently extended. In April 2022, he successfully applied for a Health and Social Care Skilled Worker Migrant Visa. Under these visas, dependent children under 18 can join their parent in the UK. However, applications for children over 18 are assessed independently and granted only in exceptional circumstances. Dr. Ashfaque provided different dates of birth for his sons in different visa applications, indicating discrepancies in their ages. The concerns regarding the applications for Mr. A and Mr. B arose when the photographs in their passports appeared to show them as older than their stated ages. The applications were referred to UK Visas and Immigration for further consideration, which revealed inconsistencies in the dates of birth and ages of the sons. Dr. Ashfaque was interviewed by the Entry Clearance Manager on the 10th of January 2022, during which he initially claimed the dates of birth provided in the recent visa applications were correct. However, when confronted with the different dates of birth provided in previous applications, he admitted to altering his sons' ages to bring them to the UK due to educational reasons. As a result of Dr. Ashfaque's admissions, the applications for PBS visas for his sons were refused. He later attempted to withdraw the applications, but since they had already been refused, the withdrawal was not possible. The concerns regarding Dr. Ashfaque's visa applications and his sons' ages were reported to the General Medical Council by the UKVI Operations Manager. The GMC notified the trust about the investigation, but the trust did not conduct its own internal investigation as there were no concerns about Dr. Ashfaque's patient care, although the allegations regarding his probity were acknowledged. At the outset, the doctor admitted all the allegations. During the hearing, Dr. Ashfaque provided oral evidence regarding the allegations against him. He stated that he had worked in various countries before coming to the UK in 2018 and had been employed at the trust since September 2020. He confirmed that his wife and children lived in Bangladesh, and he financially supported them. Dr. Ashfaque admitted that he was not certain about his children's exact dates of birth and relied on his wife for that information. He acknowledged providing incorrect dates of birth in several visa applications, including Tier 2, HSC, and PBS visas. He explained that he changed the dates of birth for his sons because they were behind in their education and not receiving the subjects he deemed important. He believed they were emotionally immature due to not being in mainstream education and wanted to enhance their educational opportunities by enrolling them in lower year groups. Dr. Ashfaque discussed the process of obtaining passports and birth certificates in Bangladesh, mentioning that birth certificates were not issued at the time of birth. He stated that changing dates of birth during school enrollment was common in Bangladesh and that he had changed his son's dates of birth twice for educational purposes. He confirmed the correct dates of birth for his sons and acknowledged the incorrect dates provided in the visa applications on the 29th of August 2017 and the 17th of November 2017. He clarified that those applications did not involve any intention for his sons to visit or join him in the UK. Regarding the intent of Mr. A and Mr. B's PBS visa application, Dr. Ashfaque stated that they would have attended a local school. He addressed concerns about placing adult men in a classroom with children, expressing confidence in his son's small stature, emotional immaturity, and polite nature. Dr. Ashfaque admitted to not fully understanding the scope of good medical practice but recognized its importance after attending probity and ethics courses. He expressed remorse for his actions and pledged not to be dishonest again or make applications for his sons. He emphasized his dedication to medicine as a noble profession, enjoying patient care and positive outcomes. He assured the tribunal of his commitment to honesty and expressed his happiness in his medical career. In summary, Dr. Ashfaque's oral evidence included admissions of altering his son's dates of birth, his motivations for doing so, his limited understanding of good medical practice, his subsequent realization of the importance of honesty, and his remorse for his actions, acknowledging the impact on the medical profession's reputation.
During the hearing, the counsel for the General Medical Council argued that determining whether Dr. Ashfaque's fitness to practice was impaired was a matter of judgment rather than proof. She emphasized the importance of protecting the public, maintaining confidence in the medical profession, and upholding professional standards. The council found it alarming that despite practicing medicine in the UK since 2018, Dr. Ashfaque claimed not to have been fully aware of the importance of good medical practice. She highlighted his extensive experience as a doctor and contended that his conduct breached GMP standards, constituting serious misconduct and bringing the profession into disrepute. Referring to the test for impairment, argued that Dr. Ashfaque's fitness to practice was impaired. While there were no clinical concerns, she stated that his actions breached a fundamental tenet of the profession, involved admitted dishonesty, and brought the medical profession into disrepute. The council pointed out the delayed development of Dr. Ashfaque's insight and lack of proper understanding, regret, and timely remediation. She highlighted his inadequate response to safeguarding concerns and the delay in attending the probity and ethics course, suggesting limited insight into his conduct. Based on the evidence, the council concluded that Dr. Ashfaque's fitness to practice was impaired due to misconduct. The council, representing Dr. Ashfaque, acknowledged the likelihood of finding misconduct in the case and Dr. Ashfaque's acceptance of his wrongdoing. She emphasized the tribunal's responsibility to determine whether his fitness to practice was impaired, considering the statutory objective. While acknowledging the seriousness of the misconduct, the council argued that it could be addressed and remedied. The council highlighted Dr. Ashfaque's consistent admission of his actions, recognition of the seriousness of the allegation, and candid testimony. She acknowledged his lack of familiarity with GMP principles and suggested that his motivation for changing the dates of birth of his sons might be related to their education rather than sinister intentions. Regarding the Tier 2 visa application, the council argued that Dr. Ashfaque gained no advantage from providing incorrect dates of birth, indicating his lack of consideration rather than intentional deception. She emphasized his efforts towards remediation, including apologies, reflection, and engagement with relevant courses on probity and ethics, which enhanced his understanding of GMP. The council asserted that there was a low risk of recurrence of misconduct based on Dr. Ashfaque's acknowledgement, reflection, and testimonials supporting his overall honesty and integrity. She contended that his insight had developed over time through engagement with the regulatory process, acceptance of his behavior, and the impact of his actions on the profession's reputation. In conclusion, the council argued that Dr. Ashfaque had shown good insight through his admissions, remediation efforts, and reflection. She emphasized his readiness to accept responsibility, engagement with the process, and understanding of the consequences, asserting that the evolution of insight over time did not diminish its value. The tribunal determined that Dr. Ashfaque's actions constituted misconduct as he admitted to providing false information on visa applications and breaching key principles of good medical practice, including honesty and integrity. His repeated dishonesty over a significant period undermined public trust and the reputation of the medical profession. The tribunal concluded that his conduct amounted to serious misconduct. Regarding impairment, the tribunal assessed whether Dr. Ashfaque's actions put patients at risk, brought disrepute to the medical profession, breached fundamental professional tenets, or involved dishonesty. Although there were no clinical concerns, his dishonest conduct met these criteria. While recognizing his remorse and acceptance of responsibility, the tribunal found limitations in his insight and remediation efforts. His attendance at ethics courses was recent and prompted by recommendations rather than personal initiative. The tribunal considered his insight to be in the early stages of development and expressed concern about the risk of repetition. Balancing his insight, remediation attempts, and the risk of repetition, the tribunal concluded that impairment existed in each aspect of the statutory overarching objective. Dishonesty, breach of professional tenets, and significant deviation from standards were impairing factors. They found his conduct failed to protect the public's health, safety, and well-being, particularly vulnerable children. The tribunal emphasized the importance of maintaining public confidence in the medical profession and the disciplinary process. Therefore, it concluded that Dr. Ashfaque's fitness to practice was impaired due to his misconduct.
On behalf of the GMC, the Council presented submissions regarding the appropriate sanction for Dr. Ashfaque. She reminded the Tribunal that the decision on sanction is within its jurisdiction and should follow a staged approach, starting with the least restrictive option and progressing to more severe measures. The Council emphasized that the sanction decision should consider the statutory overarching objective. Referring to the Tribunal's previous findings of misconduct and impairment, the Council acknowledged the presence of mitigating factors, such as Dr. Ashfaque's limited insight and attempts at remediation. However, she argued that his conduct exhibited a serious and reckless disregard for good medical practice, with persistent dishonesty and a persistent lack of understanding regarding the gravity of his misconduct. In light of these considerations, the Council contended that the appropriate sanction for Dr. Ashfaque would be erasure from the medical register. On behalf of Dr. Ashfaque, the Council presented submissions opposing the sanction of erasure. She argued that erasure would be disproportionate and unnecessary to protect the public, suggesting that public confidence in the medical profession could be maintained with a lesser sanction. The Council emphasized that Dr. Ashfaque acknowledged the seriousness of his misconduct and highlighted his qualities as a dedicated and highly valued doctor with no concerns about his clinical skills or competence. The Council pointed out that Dr. Ashfaque had been open and honest with his colleagues and during the GMC investigation, demonstrating his recognition of his wrongdoing. She asserted that there were no probity concerns in other areas of his life, and the issue of his intentions regarding his children's schooling did not arise during his appraisal with Dr. F. The Council highlighted several mitigating factors, including Dr. Ashfaque's developing insight, attempts at remediation, full and public apologies, adherence to GMP, and a lack of previous adverse fitness to practice history. She acknowledged the seriousness of cases involving dishonesty but argued that erasure was not inevitable, considering that his dishonesty, while repeated, was not persistent or sustained. Regarding the public interest, the Council stated that it had already been addressed by the Tribunal's findings of misconduct and impairment. She suggested that the public interest would be best served by imposing a period of suspension, allowing Dr. Ashfaque to eventually return to work. The Tribunal approached the decision on the appropriate sanction independently, considering the statutory overarching objective of protecting the public, maintaining public confidence, and upholding professional standards. They found aggravating factors such as repeated dishonesty, disregard for immigration rules, and a lack of concern for the potential impact of his actions. Mitigating factors included developing insight, admissions, apologies, and positive testimonials. After considering various sanctions, the Tribunal determined that taking no action or imposing conditions were not appropriate. They concluded that a period of suspension was necessary to address the seriousness of the misconduct, maintain public confidence, and provide an opportunity for Dr. Ashfaque to gain further insight and engage in remediation. Regarding the GMC's submission for erasure, the Tribunal found that Dr. Ashfaque's actions did not demonstrate a persistent lack of insight or a deep-seated attitudinal problem. They concluded that suspension would sufficiently mark the seriousness of the misconduct, protect public confidence, and uphold professional standards, aligning with the statutory objective of protecting the public interest. Erasure was deemed disproportionate and excessively punitive in this case. The Tribunal imposed a 12-month suspension on Dr. Ashfaque as the appropriate sanction, considering the seriousness of the misconduct, the potential risk to children, and the identified aggravating and mitigating factors. A review hearing would be conducted before the end of the suspension period, where Dr. Ashfaque would need to demonstrate his fitness to practice is no longer impaired. No immediate order was imposed following the suspension, as the Tribunal deemed it unnecessary based on the specific circumstances of the case, lack of clinical concerns, limited scope of dishonesty, and the effectiveness of the substantive sanction. The case was concluded, and Dr. Ashfaque's registration would be suspended 28 days from the date of written notification, unless he appeals the decision.